before we get to all that, Miss Cristina, would you please tell me a little bit about yourself?
Yes. So I'm a professor at Yale Law School. I've been teaching constitutional law, administrative law, and immigration law for about 20 years. And I've also worked in the Department of Justice and done a lot of government side immigration work and policy.
Well, I am so tickled to get to meet you. And of course, I am hopelessly outclassed, but I will do my best anyway.
Well, I'm glad we have the chance to have this conversation.
Thank you.
And Rod, do you want to do a little quick intro back?
Oh, sure. I'm sorry. You don't have any reason to know who I am. I'm Rod Martin. I was one of the early guys at PayPal, actually very pro-immigration. I don't think that the Constitution requires this particular thing, but I'm a technology entrepreneur. I'm a venture capitalist, and have been involved in the Republican Party for a long time. I also have a law degree. I'm just not practicing currently.
Makes sense. Good to know.
Thanks, Cristina Rod. I'm the only non-lawyer in the bunch, but I'll just kick us off here. So, of course, we're here to talk about birthright citizenship, and I'll just say that growing up, I think, like a lot of people, I was taught that birthright citizenship, this idea that if you were born in this country, you were a U.S. citizen.
Oh, yeah,
I grew up not only thinking that was enshrined in our Constitution, but also a part of our identity in terms of who we were as a country. You know, we were a nation of immigrants. So this was a core part of who we were. So I have to say that I was a bit thrown when I first started hearing the narrative about even questioning the idea of birthright citizenship. And then, of course, on kind of day one in office, President Trump issued the executive order protecting the meaning and value of American citizenship and did exactly that, raised the question of whether parents who were here illegally were under the jurisdiction of the U.S. government, and therefore whether their children were entitled to citizenship. So as we have this conversation, I want to make sure we can do two things. One, talk about the legal issue of what is in our Constitution or not. And Cristina, you are our constitutional scholar. But I also want to talk about more broadly what is happening here and what's driving this dialogue at all. So let's start with the legal question, though, because that feels like the big one. Cristina, I'll open it up to you. Is the right to birthright citizenship embedded in the Constitution, in the 14th Amendment?
It's very clearly embedded in the 14th Amendment. I don't think there's any ambiguity about that. I would start by emphasizing what you were taught, which is that it is part of our constitutional heritage. And there is a centuries-long comprehensive practice across the legal system of acknowledging that people who are born in the United States are citizens of the United States, with the exception of three very specific, very limited exceptions that are very rarely relevant. And the executive branch has, until the current administration, held that position. The states have held that position. Local governments and hospitals have behaved in that fashion. And Congress has adopted two statutes that repeat the language of the 14th Amendment in 1940 and then in 1952 against a backdrop of this practice. And so it's not just a question of whether it's in the Constitution, it's also a matter of federal statutory law, which is relevant to the legality of the executive order. And I'm sure we'll have the opportunity to get into Supreme Court precedent and the history of the 14th Amendment's enactment to understand why that long unbroken practice is the correct practice. But it is very firmly embedded in our understanding of citizenship.
And so, Rod, would you disagree with that?
Yes, absolutely. I would.
All right, well, kick us off, jump in there.
Yeah, and, historically, I would have completely agreed with that. But the more I look at the case law, the more clearly I think that's mistaken. I think the intent is good. I mean, I'm very pro-immigration. I always have been, and I was personally born on a U.S. air base in Wiesbaden, Germany. So, I'm all for being a natural-born citizen as a result of that. I don't think that we should be harming people in any needless way. And I would add that what Donald Trump is talking about certainly would not apply retroactively. If we have told people one thing, we're going to maintain that one thing, and anything else we're talking about would be a go forward matter. But the truth of the matter is, this just wasn't what the framers of the 14th Amendment were trying to do. They were trying to give citizenship to former slaves. These are people who have always been under the jurisdiction of the United States. We banned the slave trade in 1808. So basically any slave in the United States at that point has been under the jurisdiction of the United States most, if not all, of his or her life. And so they narrowly tailored this language. Only those people subject to its jurisdiction, quote unquote. Well, that's interesting because we explicitly exempt some people from that, and that's very telling as to what the phrase means. Specifically, here's what the U.S. Citizenship and Immigration Services website has to say. Quote, a person born in the United States to a foreign diplomatic officer accredited to the United States is not subject to the jurisdiction of United States law. Therefore, that person cannot be considered a U.S. citizen at birth under the 14th Amendment to the United States Constitution. Well, why not? If they're born here, obviously citizenship immediately attaches, but clearly that's not the law, nor has it ever been. And the truth is, the Supreme Court was very clear on this in the slaughterhouse cases. They said very plainly that the phrase was intended to exclude children of foreign diplomats, consuls, and foreign nationals born on U.S. soil. Well, that's what an illegal alien is. That's somebody who has come here other than by law. They're blatantly violating the law, and they have a child here that shouldn't entitle them to special rights. That's gaming the system. So I would like to have more citizens. I'd love to have more immigration, but they need to come through the door and not break in the window.
So can I jump in there first to emphasize that the framers of the 14th Amendment did understand that what they were doing was to overrule the Dred Scott decision, which was a Supreme Court decision in 1857, which said blacks could not be citizens because the framers of the Constitution didn't think them qualified or capable of becoming citizens. But they wrote the 14th Amendment in general language. And there was extensive debate about the scope of the Citizenship Clause when Congress was thinking about the 14th Amendment. And in that debate, one senator, I believe he was from Pennsylvania, asks, well, given the way that we've written this, does this mean that the children of the Chinese will be citizens if they're born in the United States? At the time, Chinese could not naturalize. They were not thought to be capable of citizenship because they were loyal to the emperor of China. Does this mean that gypsies will be citizens of the United States if they're born in the United States? And the supporters of the amendment and those who voted for it said, yes, that's what it means. We're writing this in general language. So it does mean that the children of foreign nationals are citizens of the United States if they're born in the United States. And among the reasons for that was that there were lots of immigrants in the U.S. at the time. And to say that someone who was the child of a foreign national would not be a citizen of the United States would mean the children of Germans, the English, the Irish would not be citizens, people from Scandinavia. And that was a bridge too far. And they understood that even people who they did not think were capable of being citizens, like the Chinese, if they had children in the United States, they would be citizens of the United States. So then that leads us to the question that Rod has pointed out, which is, well, what do they mean by subject to the jurisdiction thereof? And that's where it's important to be specific. So Rod has already pointed to one of the specific examples they had in mind, and that is children born to foreign diplomats and consuls. They are not under the jurisdiction of the United States, those parents, and neither are their children because they are not subject to U.S. law in the same way as everybody else. The other example that they talked about during the debates and that's been part of Supreme Court case law are the children of those who are born here under enemy occupation. So if you have an occupying hostile army or country in the United States, their children are not citizens of the United States. And then in the US, there's also the special exception of the children of Indians or Native Americans. And that's something that's more complicated and unique to the US context. The other exceptions come from English common law.
Statute later on.
Yeah, resolved by statute later on. Exactly. So those are narrow and specific exceptions to the very general rule. So then we have to have a conversation, which I think we should, about why it is that there's something special about immigrants who are in the United States having crossed the border unlawfully or overstayed their visa. Why are their children treated differently? I should note that the executive order extends much more broadly than that it encompasses also people who are here on temporary visas, on H-1B, student visas, tourist visas. So it's not just people who violated the law.
Keyword being temporary.
It covers people whose parents are here temporarily. And the short answer I would give to that question, and we can talk at length about it, is that the 14th Amendment is very clearly about children. It is not about parents. And the amendment as a whole is meant to repudiate the idea that inheritance determines status, that your ancestry or your parents determine your status. The status attaches to the person born in the United States. That is a conceptual difference from the way that it has citizenship has passed down in other countries that comes from the common law, but it's also central to what I would identify as the anti-caste principles of the 14th Amendment. And so that's why I think that the exceptions actually prove the rule.
Well, and I strongly agree with Professor Rodriguez on the principle. I just respectfully disagree with the application. The temporary visa, for example, that is not anyone who intends to be here permanently. So why on earth would their children born here who are going back to Germany or going back to Kenya be a citizen of the United States? It's just nonsense. And likewise, an illegal alien is certainly coming here for the purpose of having a child so that they can have an attachment to the United States, so that they can qualify for certain benefits and privileges of being in the United States, but they're not doing it lawfully. So, I mean, by definition, they're not subject to the jurisdiction of the United States. They have willfully chosen to not be and violate its law as their first act of entering the country. So
Rod, can I just jump in there? Because I think you've raised two different things. One is this question of temporary versus permanent kind of resident. And does that make sense? But the other piece you raised was this idea that people are gaming the system, that they're coming here to have a child, to have a path to citizenship. And I feel like this is a hairy, messy area. So I want to be able to talk about both of these separately. So let's start with the temporary versus permanent resident piece, because Cristina, thank you for calling me out. The executive order is not just about legal versus illegal immigrants. It's also about temporary versus permanent kind of residency here. So let's start there, and then we'll get to the other piece. Cristina, maybe I can open up to you.
I'll say that the constitutional provision and the two statutes that I referred to, the federal statutes, draw no distinction between whether someone is here permanently or temporarily. And we can trace that all the way back to Wong Kim Ark, which is the Supreme Court decision in 1898, which established clearly that the 14th Amendment covers the children of Chinese immigrants. That was an unsettled question because of the Chinese antipathy. Immigrants. Well, the nothing turns on the legality of their status, but I'm addressing the temporary issue.
Kind of important.
I'm addressing the temporary issue first. The temporary issue also plays no role in that case because Wong Kim Ark's parents had left and gone back to China. It was a fairly typical practice during that period for Chinese immigrants to come to work, whether it was to work on the railroads or to work otherwise, and after a time to then go back to China. That back and forth was relatively common. So this idea that there were clearly temporary and clearly permanent immigrants doesn't make sense of that history. And so the Constitution doesn't draw that distinction, and none of the debates draw that distinction. It doesn't matter if the parents have returned to their countries of origin or what their intent was. Their children are citizens if born in the United States. The other thing I would say is that the categories of temporary visas are diverse and vast. So the executive order would also cover people who are on not just tourist visas, but H-1B visas. And many people on H-1B visas are here for extended periods of time, and then they adjust status to permanent residency. One of the very common routes to permanent residency in the United States is through these temporary statuses. And so it's proves too much to say that because someone's on a temporary visa, they don't have the intention to remain. Our system is much more fluid than that. And the fact of the matter is that the Constitution doesn't draw that distinction. And so for an executive order to try to draw that distinction goes contrary to both the Constitution and the statute and doesn't actually align with the intentions of people within the system itself.
I would suggest that if that's so, every child of every foreign diplomat must be a citizen as a matter of constitutional law. There is simply no distinction, you're saying, between these people. Well, diplomats are temporary, they don't intend to stay, and their children are born in Bethesda, they should be citizens. And what we're doing and have been doing now for a century should be unconstitutional. Now, if you want to argue that, that's fine. I'm for that. But unless we're arguing for that, then clearly there is a distinction between some classes of aliens and others. And in that case, I think we come back to Wong Kim Ark, where the parents actually were legally resident in the United States. Now, they did go home because we don't have a law that requires you to stay in the United States forever. I could immigrate to Venezuela if I wanted to, but I'm not going to, but I might. So that doesn't change my citizenship status, and it didn't change their legal residency status. So Wong Kim Ark is a legitimate subject of the U.S. jurisdiction, and rightly, and her case was rightly decided. But you look back at the line of cases before that, Slaughterhouse, Elk v. Wilkins, there's a very clear distinction that people who are not subject to the jurisdiction of the United States in the manner that I'm describing are in fact not citizens, or at least their children are not citizens. So all I would say to that is Congress has shockingly broad power to regulate citizenship and naturalization. And we saw that in the case of the Indian tribes that you cited earlier. Originally, they were exempted because even though they live in the United States, they were considered to be citizens of a different nation. And in the 20s, we came back and said, no, that's not right. Let's let those guys be citizens too. Well, okay, same thing here. If we want to make the children of illegal aliens automatically citizens, clarify the law. Let Congress pass this. I think that's a bad idea. I don't know why we would encourage gaming the system, which I know is our next topic, but if that's the principle we want to uphold, there's an easy way to do it.
Well, I would emphasize again, Congress has already done that in 1940 and 1952, clearly adopted the same language as the Constitution against a backdrop of acknowledging that temporary status, illegal status, none of that matters to the rights and citizenship holder, which are the children, not the parents. The children have not violated any laws. They're just born in the United States. I would also like to emphasize, because you rightly initially brought this up, the language of subject to the jurisdiction. So the reason why I think it doesn't follow from what I've said about temporary status that the children of diplomats should also be treated as citizens is because they're not subject to the jurisdiction of the United States. But everyone who doesn't fit that category, who's in the United States, is subject to the jurisdiction of the United States. Children born in the United States who are not the children of diplomats, who are not the children of hostile occupying armies, are subject to the jurisdiction of the United States. Their parents, even if they've entered unlawfully, they are subject to the jurisdiction of the United States. They can be arrested for committing crimes. They pay taxes. They can be deported. There's no way in which they are not subject to the jurisdiction of the United States. They are not in any fashion analogous to the children of diplomats or to diplomats themselves. And they're not analogous to the way the courts and the framers of the 14th Amendment understood tribes at the time as sovereign, quasi-sovereign entities inside the United States, who were given a form of respect by being regarded as separate. The idea of subject to the jurisdiction embodies the common law rule that if you're born in the realm, you are given protection in the realm in exchange for allegiance. It's quite simple, quite straightforward. And that has been transformed into our contemporary understanding. We're not subjects to a king. We are citizens of a country, but we, by being born in the country, acquire protection from the country in exchange owe allegiance. And so it doesn't make sense to carve out this category of unauthorized immigrant from the constitutional understanding. We can certainly have a policy debate, which is where we're, I think, headed, about whether the law should be changed or the Constitution should be changed so that the children of unauthorized immigrants don't have citizenship so that people can't game the system. I would disagree with that characterization, but that's not what the Constitution contemplates. It would require not just a change of statute, but a change of the 14th Amendment.
Well, I would suggest that actually you're describing our historic understanding of this. And it's certainly the understanding that I was taught in law school. It's certainly the understanding that I had for most of my life, but it's not in the Constitution. And you're right to point out that, some of what's being said here isn't actually in the text. Well, this isn't actually in the text. This says something very specific, that they must be subject to the jurisdiction, and it doesn't elaborate. And we have since elaborated by statute and by case law that, for example, the children of the soldiers of occupying armies or the children of foreign diplomats may not be included in that. Well, actually, that's even going too far. They could be. There's no reason that Congress couldn't say that the children of a foreign diplomat is a citizen. And there's no reason that Congress couldn't say that the children of an occupying army are actually citizens. In fact, maybe they would for some reason. But the truth is, the Constitution doesn't say that. That's how we've chosen to interpret it. So it's not illegitimate to come back and question that interpretation. And then I think we do get to the policy debate of whether we want that to be the policy or not. I mean, Donald Trump clearly has his opinion. I don't disagree with it insofar as what we're really talking about is gaming the system. But if we could clarify this in a way that is more humanitarian, I'm all for that.
So, Rod, since you've pivoted us to the gaming the system piece, and I think this is important because it feels like it comes up a lot in the narrative right now.
It's the key to the debate. That's why it's come up. Yeah.
So talk to us about that. What's the fear here? Because, I hear that term a lot. Parents are gaming the system. They're coming here to have a child as a path to citizenship, as a path to being here. Talk to me about the fears. Say more.
No, it's not really a fear. It's a reality. We have millions of people coming to this country and having children. And once they have that child, they have some claim on staying here. They have some claim on benefits. They have some claim on bringing more relatives into the country. And all of those things would be legitimate if they were legally here. But if you just cross the Rio Grande and immediately give birth, that isn't entitling you to citizenship under the 14th Amendment.
But it doesn't entitle, just to clarify, just because your child is a citizen, that does not entitle the parents to citizenship.
So this is gaming the system. This is playing on our compassion, which, we should be compassionate. This is playing on the way we've chosen to interpret this law to basically create a loophole. And that's not okay. And we shouldn't allow that any more than we do in tax law.
I think there's some important facts to put on the table here. The first is that a child born in the United States cannot sponsor their parents for permanent residency until they turn 21. And so from the parents' perspective, they're not gaining access to citizenship for at least 21 years. That's the first thing. The second fact is that numbers are hard to estimate, but different estimates lead us to the conclusion that there are approximately 250 to 300,000 children born a year in the United States who become citizens who are the children of unauthorized immigrants. And only a small percentage of that 300,000 are born to people who engage in this so-called birth tourism. And I don't want to suggest that that's not a phenomenon. It is a phenomenon, but the vast majority of that 300,000 number are born to people who are unauthorized for a variety of other reasons. They may have entered the country to work. That's the primary reason people enter the country unlawfully. Or they may be refugees or asylees, people who have sought asylum, and they have children in the future. They don't enter in order to game the system. They enter for these other reasons. They create relationships. They have children. Or there are people who entered on visas. Some significant percentage of the unauthorized population entered legally, but then they overstay their visa. They don't have a path to another visa at the moment. They're in between statuses. So it's complicated, that population. So it's not just people who are gaming the system. The last thing I will say is, and I think this is the critical question, if we can all agree that the gaming that Rod is describing is a problem, that we don't want people coming to the United States strictly for the purpose of giving birth to U.S. citizens, the question is what to do about it. Is the answer to reinterpret the 14th Amendment to deny citizenship to all people born in the United States because they have a parent who was here temporarily or crossed unlawfully, regardless of whether they game the system? Or do we want to enforce the rules that already exist, which is to say, if an immigration officer has a reason to believe that someone is entering specifically for the purpose of having a baby, that person should be denied entry? And it is a mistake of significant consequence to try to make immigration policy by reinterpreting the 14th Amendment in this fashion, because what it would do is instantly create hundreds of thousands of more illegal immigrants and instantly create a second class of people in the United States. Children born with citizenship do well. There is, I don't think, anyone arguing that they are unqualified as citizens, that they are drains. But if they remain in the United States, which some significant percentage of them will, then without citizenship, they do become a problem. And so to create that problem in order to address what is a minor immigration issue has it backwards, in my opinion.
I don't think it's a minor issue because, as you rightly point out, we're talking about hundreds of thousands of people a year.
No, the birth tourism is not. No. The birth tourism is not hundreds of thousands of people per year.
Who come here for birth tourism. I don't care what their intent is. If they're illegally here, they should be expelled. They should not be allowed to be where they're not supposed to be. So if we're going to get into the policy debate, we have to actually deal with what's happening on the ground, which is wanton refusal to enforce our laws by our recent administration. And if Donald Trump's solution isn't the best, it is a very clear reaction to that abuse of the system, not so much by the illegal immigrants as by the Biden administration.
So, Rod, let me jump in there because you just raised a whole bunch of points that I think we need to unpack. So, you nailed it. Then there was a lot there. So, I think first, and you talked about, and this is separate actually from the citizenship conversation to me. You raised just immigration policy and maybe our broken immigration policy and failures to enforce immigration policy. That is an issue. Yes. That's a distinct issue from the question of citizenship and birthright citizenship.
Yes.
I feel like they got kind of pulled together there, but those are distinct policy lanes, right? So I hear you raising legitimate challenges around immigration policy in general, but again, distinct from this question of birthright citizenship. But the tool that's being used right now, and I know you want to jump in there, and sorry, I shouldn't have cut you off.
No. All I'm saying is, yes, you're right, but on the ground, it's a distinction without a difference. If people are coming here and they're having children who then become citizens, the reason they came here isn't relevant. It really doesn't matter if they were birth tourists or not. And so you're right. I think our immigration policy is a mess. And I want to stress what I said at the beginning. I'm pro-immigration. And yeah, I want all the immigrants we can get as long as they come through the door and don't break in the window. So we could increase H-1B visas. I'd be good with that. I'd be good with lots of this stuff. And I'd be very happy for these people to be healthy, productive citizens of the United States. But there's a good order in which it's supposed to happen. And our government is the chief, and I stress the chief, violator of those laws.
I'd like to make 2 points in response to that. And it sounds like, Rod, maybe this is not one of the 2 points, but it sounds like we're moving towards some agreement that if you've entered lawfully, that the children of people who've entered lawfully, including H-1B visa holders, maybe as a policy matter, they should be allowed to be citizens of the United States because there's no gaming of the system. So
in general, yes.
In general, yes.
Details
Okay.
might disagree, but yes, in principle, we're of one mind.
But then in what you say, it seems like there are 2 impulses. One relates to what I would call a punitive approach to illegal immigration. And the second relates to questions of deterrence. So if what we're saying is that people who enter unlawfully, regardless of their intention, don't deserve to have citizens as children, it sounds like the impulse is punitive. But again, I can't emphasize enough times that the 14th Amendment and the statutes that Congress has enacted are very much about the children who have done nothing wrong, divorcing the status of children from the status of their parents, getting rid of the idea of inheritance. There are other elements of the Constitution that are anti-inheritance. We don't have titles of nobility. There's no corruption of blood for treason. The basic principle that you do not inherit the sins of your parents is critical to our conception of equality and to the original meaning of the 14th Amendment and to how we've tried to implement it over time. So to the extent we're targeting the bad behavior of parents as a punitive matter, I think that should be off the table. But then you're raising some questions about deterrence. Will eliminating birthright citizenship deter unlawful immigration? Will it deter visa overstays? And I think the answer is almost certainly no. It might stop these birthright or birth tour arrangements that people engage in. But as I suggested before, there are 2 primary reasons why people violate immigration laws to either come to the United States or stay in the United States. The first is to work. That was true throughout the massive wave of illegal immigration of the 80s and 90s and 2000s, which is basically over. But many millions of people who came in that fashion remain in the United States. And the second is seeking refuge or protection. And that is also a legitimate reason to come to the United States under our laws and under our international obligations, under U.S. law, under international law. And to say then that we are going to change the entire meaning of the 14th Amendment in order to deter illegal immigration doesn't actually take account of the reason people come, because people will still have those motivations to work, to seek refuge. And so then you have to ask, are the costs of changing the meaning of birthright citizenship worth it if their deterrent value is minimal? If the deterrent value is only for people who come with a specific and immediate intent to have children, not to work, not to seek refuge. And that's where having 300,000 people a year who would have been citizens and who were blameless suddenly become illegal immigrants themselves just doesn't seem worth it to me. That makes them more pliant employees. It makes them unable to progress through the system of education. It makes them more likely to become public charges, both as children and as adults. And then it makes them targets for deportation, which is not something that I think we ought to be expanding to include people who are themselves blameless, who made no decision to enter the United States unlawfully. And so the costs of undoing birthright citizenship for minimal deterrent value to illegal immigration don't seem worth it as a policy matter, and in fact are inconsistent with a kind of country that we ought to be trying to build, which is one that doesn't depend on your parents' status, doesn't depend on inheritance, doesn't depend on ancestry, doesn't depend on race, but gives everyone at birth an equal chance to succeed. And that's what the Birthright Citizenship Clause does.
Look, I agree with most of what you're saying there. I would just come at it from a different point of view. No one is entitled to be a U.S. citizen. There's 96% of the human population outside of our borders, and not one of them is entitled to U.S. citizenship. So it cannot be punitive for one of their children to not get something to which they are not entitled. And all of this rests on a particular interpretation of the 14th Amendment, which, by the way, we could also challenge in court. And I'm sure we will because of what President Trump has done. I'm sure we will have Supreme Court case law on whether or not his executive order is legitimate. Well, legitimate's not even the right word, just constitutional. So we're going to see. And perhaps we should modify policy, even if the Supreme Court agrees or disagrees with the president. That's not the end of the debate. That's the end of the debate on what the original meaning of the 14th Amendment is as relates to this issue. Like I said, I'm pro-immigration. I want to be compassionate. I'm grateful for a lot of your stands expressed here on divorcing the sins of the father from the sons. But at the same time, it is not an entitlement of a foreign national to become a citizen.
No, if you think no one is entitled to become a citizen, then does that mean that if a parent commits a crime, maybe a parent commits tax evasion their entire lives, has not fully subjected themselves to the jurisdiction of the United States by avoiding taxes, does the child then, after those crimes have been committed, could Congress decide that that child is not a citizen of the United States because the parent himself should be stripped of their citizenship?
Well, of course
it is incorrect to say that no one is entitled to citizenship.
There's a congruity there that doesn't exist. They weren't entitled to be a citizen. It is an accident of birth that they happened to be here. That does not attach citizenship to them if they weren't here legally. And the truth is, the child also is not here legally. And it's not punitive because the child wasn't entitled to U.S. citizenship in the first place.
Yes, they were. No, that's incorrect.
The
Under
child
the Constitution,
in Ireland is entitled to Irish citizenship, not to U.S. citizenship.
So just to jump in here, Catherine, Christina, I apologize. Just to clarify. So the 14th Amendment, what it says in Section 1 is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside, right?
Yes.
That is literally what's in the 14th Amendment.
Yes.
So, and the statutes and the federal statutes.
Yes.
So as a matter of law, those children are entitled to citizenship. It is an entitlement. It is not something that can be taken away. Once you naturalize, you are entitled to citizenship. It is very, very difficult to denaturalize someone for good reason.
And it should be.
Because we think of that as an entitlement. So if you want to say that those children are not entitled to citizenship, then you have to succeed in making the claim that we've been misinterpreting the Constitution for 100 years. And perhaps that's what the Supreme Court... Perhaps that's what the Supreme Court will say. I think they will be wrong in a profound way if that's what they say, but perhaps the Supreme Court will say that. And then you can say these children are not entitled to citizenship. But the Supreme Court would also have to say that the federal laws that Congress has enacted, assuming that all people born, regardless of who they are, regardless of their parents, are citizens of the United States, are also wrong or somehow in need of reinterpretation.
Congress has explicitly exempted people that you have specifically identified. And if what you're saying is absolutely bedrock constitutional law, then Congress has been erring and has been acting unconstitutionally for most of a century. Every child of a diplomat must be a citizen.
No, I acknowledge that exception. No, I acknowledge that exception from the beginning.
U.S. soil, and they're entitled to U.S. citizenship. And my contention is, no, they're not entitled to U.S. citizenship because they are citizens of another country. A child born just 1 inch past the Rio Grande boundary is a citizen of whatever country that its parents came from. And this isn't a hard distinction. If we want to change that, okay, and we have in practice for decades, what I understand us to be arguing is, does the language of the 14th Amendment expressly require it? And the only cases we have on point, as you know, are the slaughterhouse cases, Elk v. Wilkins and Wong Kim Ark, all of which uphold what I'm saying. So I think we're at a point where We are having this discussion 100% in reaction to abuse of the system, far more by our government than by any individuals. And this is just what we'd say in the church: sin begets sin. You have an abuse on the one side that is now producing a reaction. And honestly, I wish we didn't have to have this argument at all, but we do because of the sheer scale of the criminality.
So you're incorrect about Wong Kim Ark. Wong Kim Ark is fully consistent with the subsequent practice.
Well, I know you.
And our subsequent practice emanates from Wong Kim Ark. What you're citing from the slaughterhouse cases, which was a set of cases brought by butchers in Louisiana who didn't like a local regulation about where they could slaughter their meat, who argued that their rights were being violated under the 14th Amendment, has nothing directly to do with this question. There is some language about citizenship in those cases, but those cases are about whether the Privileges and Immunities Clause, the Equal Protection Clause, and the Due Process Clause preclude Louisiana or the city of New Orleans from adopting a law that requires all slaughtering of animals to be conducted in one part of the city. So that case cannot support the position that you're taking.
I disagree. I think it shows very clearly what the Supreme Court thought the intent of the 14th Amendment was, and I think that they came back in Elk v. Wilkins and said basically the same thing. And Wong Kim Ark, I understand why you're using it. I would have used it 10 years ago the same way, but Wong Kim Ark's parents were legal residents of the United States. And that is a pretty important distinction. Does it mean that what I'm suggesting should be the public policy of the United States? No, not necessarily. But it does mean that what the language of the 14th Amendment compels is more limited than has been claimed by basically all of us for decades. And that actually opens up room for us to have this discussion. Whether we should be having the discussion is another matter. Whether it should come out a particular way is another matter. I actually think birthright citizenship in these cases is a bad idea, and I think it encourages criminal behavior. But in general, a more compassionate approach is good. In general, we want more immigration, not less. I know that's a controversial statement in some of my own quarters, but I know what the demographic numbers look like globally, and America's gonna need a lot of immigration, not least because our own total fertility rate isn't that great. And, robots are awesome. I'm all for Elon, but the truth is they don't buy houses or cars. So we actually need people. And so in general, I'm agreeing with you. I just think the application of the specific language is more limited than is being claimed, not just by you, but by basically everybody.
Okay, so I want to put a pin in the interpretation of the 14th Amendment just for a moment. I know we need to come back to it, and we need to come back to what happens in the courts from here on. But I want to come back to something that, Rod, you've alluded to again and again, which is, I think it's a fear, right? A fear of abuse of the system, a fear of.
It's not a fear. It goes on every day. It has been forever. I mean, decades and decades of this. We're not fearing it. We're just diagnosing it.
Right. And I guess where I was going with this is many countries, when they've seen significant spikes in immigration, come back to this question of citizenship. And what does it mean to be a citizen? I think we saw that in England and Australia and Ireland and New Zealand, all since the 80s, have sort of reframed how they thought about citizenship and have made pivots from, concepts more similar to birthright citizenship to going back to laws that are based more around ancestry or bloodlines.
Yeah,
so this is a typical response that can happen in when there are spikes in immigration. Rod, I heard you just say we don't want that, right? That's the antithesis of who we are.
At least I don't.
As Americans, right?
Yeah, that's not the point here. The point here is we have a loophole that is being exploited, and we should close those. Whether it's the tax code or an environmental regulation or immigration law, it really doesn't make any difference. The whole world doesn't have an entitlement to Social Security and food stamps. That's the bottom line. And we are running a $2 trillion annual deficit, and somewhere along the way, we decided that literally anybody who wants to come here gets to, and that's just not the law. It's also not common sense. So,
Catherine, can I intervene with two? I feel
Cristina,
like we've covered this ground already, but I want to emphasize it again. The first point is to say that if you think that eliminating birthright citizenship is going to stop illegal immigration, then you are badly mistaken. Then you have to reckon with adopting a policy that has very little benefit and a series of significant costs.
I think it has a lot of
that is backwards. Let me finish what I have to say. Okay. Again, the reasons people come illegal are primarily to work, or to keep working if they've overstayed their visas, or to seek refuge. And changing birthright citizenship will not change that. Other aspects of immigration policy can, and I'd be more than happy at some other time to talk about what those other immigration policies should be to ensure that everyone comes the right way. I think we can broadly agree on that basic premise.
And I have no doubt that you are expert on that, and I would love to hear what you have to say.
Yeah. So but the second point is that if you were to eliminate birthright citizenship, what you would then be doing is turning into illegal immigrants hundreds of thousands of people who are blameless. Hundreds of thousands of people who are much more likely to succeed and be productive members of society and provide the backbone that you're suggesting that we need immigration for than if they were in illegal status. And so that is the cost. I'm not finished, Rod. I'm not finished. That is the cost of changing birthright citizenship in order to deter illegal immigration. The cost of those 300,000 people a year who are blameless, moving from being citizens with equal opportunities in the country to becoming unauthorized immigrants, deportable, unable to work, unable to succeed. And that is what does not make sense. That kind of consequence, that kind of unequal effects on people born in the United States is precisely what the 14th Amendment and the statutes that have repeated it are meant to prevent. Those laws ensure that each generation starts anew. Those laws ensure that all children have equal opportunities by having the secure status of citizenship that cannot be taken away from them. And I want to again emphasize that even if you say this particular executive order only has prospective effect, if we come to the conclusion, if the Supreme Court comes to the conclusion, if the administration comes to the conclusion, if you convince enough people to come to the conclusion that we've been misinterpreting the 14th Amendment all along, then there are millions of people in this country who are now citizens who are not supposed to be citizens. And there is nothing other than our good grace to stop the government from taking that citizenship away. And so this is what you're unleashing by reinterpreting the Constitution and pinning it on the illegal status of the parents. As Catherine suggests, there are countries around the world that have our common law rule that have a different law. In the UK and Ireland, to be a citizen in the United States by birth, one of your parents has to be a permanent resident or a citizen. So you can have a system that operates in that fashion. But those are not countries that have large-scale illegal immigration like we've had. Those are not countries of immigration like the United States is, like Canada is. And one of the things that has made Canada and the United States both really successful immigrant countries is this renewal through the birthright citizenship clause. And so I don't think that those other systems work for the kind of countries that we are and that you yourself agree we should continue to be, which is a country of immigration.
Well, I would just say that I do not, no matter how blameless I am, I'm not entitled to your car. And I'm not entitled to live in your house. And it does not harm my rights in any way to be excluded from your house. I would love to come over. We can have dinner and talk about this. That'd be fun. You can come to mine. But I gave you permission. And you would be giving me permission. And that's the thing here. None of these people's rights are harmed by not being a citizen. In fact, they're not even prevented from being here necessarily. There's no reason that those children couldn't come to the United States and work here. And if we design our immigration system a little better, we could make it easier for them to do so. You don't have to be a citizen to be in the United States. And we keep talking about H-1B visas. You know, I have background in Silicon Valley. So I remember very well back during the tech bust when we had about a 6-month period in which 50,000 Indians had to leave the country because the terms of their visa were that if they lost their job and they couldn't replace it within 10 days, they had to go. I think that's crazy. I think that's absolutely nuts. I mean, we're getting rid of some of the best people in the country from a productivity perspective and just a sheer intellect perspective. And we know what they did. They went and founded Bangalore, as a tech center in India to compete with Silicon Valley. So it's just stupid. It's absurd. But that doesn't mean they were entitled to be citizens or their children were entitled to be citizens just because they're there. And I'm not arguing with you that we might not want to have this policy debate. I'm simply arguing that the 14th Amendment does not require what we're saying it requires. It does not entitle 96% of the human population to just become citizens or their children become citizens just because they want it to be. We actually get a say in that too, just like you get a say over who comes into your house.
First of all, I don't think that's a good analogy because your car is something that requires exclusion. The 14th Amendment makes... No.
The country without borders isn't a country.
The 14th Amendment is not an open borders policy. The way it has always been interpreted is the inclusion rule that reaches the children who are born in the United States. That is what was decided in the 14th Amendment in order to ensure that some later government could not decide, Chinese people, you know what? We don't think they're capable of being citizens. Blacks, we don't think that they're good enough to be citizens. The children of illegal immigrants, they're not good enough to be citizens. The 14th Amendment is meant to prevent that. It is an entitlement, and Congress has adopted laws to reinforce that under that understanding. And so that is the entitlement. That means that those people have already, the children, been given the right to citizenship. And there are all kinds of barriers to their parents becoming citizens. The first being that they can't be sponsored for permanent residency until they're 21. If they've been present in the United States for a certain number of days unlawfully, they have to go back to their countries of origin for 5 to 10 years. And then perhaps they can come in. There are lots of ways of dealing with that problem. But the 14th Amendment and the subsequent statutes are themselves the entitlement. They are the car. Okay. And so if you want to shift that, you have to rethink 100 years of practice. You're going to have to the court's going to have to overrule Wong Kim Ark. And then Congress is going to have to overrule those statutes and explicitly say who is entitled to citizenship and who isn't. Those are all the things that have to happen. But those would be reversing constitutional and statutory entitlements, not just saying you can't have my car. So I think that we're making a category error by treating citizenship in the way that you keep treating it.
I think you're acting as though we don't overturn case law. And there isn't any good case law to support the position you're taking. So we're not even overturning that. But we overturned Plessy. We overturned Roe. We overturned Chevron. We overturn things all the time. And it doesn't mean that you weren't subject to the law as it was applied at the time that it was applied. It does mean that going forward, we're not going to do it that way anymore. And that is always subject to the Supreme Court's interpretation of what exactly do these words mean? And I'm saying these words are more limited than has been claimed, that if you want it to be as broad as claimed, we can do that. But it is a completely legitimate position for the president to take that, in fact, this isn't what the amendment intended, and there's good reason to think otherwise.
So I 100% agree with you that case law can be and is overturned. It's also a separate debate about whether the court's doing that in an appropriate fashion at the moment. And I understand that people could disagree with that people might take your view that the deterrent effect of eliminating birthright citizenship makes sense. That's why the UK and Ireland changed their rule. They didn't want asylum seekers coming and giving birth to citizens. But both of those countries have more ethnic conceptions of citizenship than we do, even though they inherited the common law rule, which is not a descent-based rule of citizenship. And so I would be on the side of making the argument that even though the United States and Canada and Mexico and some other countries in this hemisphere are different from the rest of the democratic world, that difference is a virtue. And that's why proponents of birthright citizenship have to be having the discussion we're having here, which is not just the legal question, but the moral question, the policy question. And there, I think there's a lot more room for disagreement and understand where you're coming from.
And of course, I think if you're here legally, your children should be citizens. That is the plain meaning of the 14th Amendment.
But you're also, apart from the constitutional argument, then making a policy argument about whether or not people who enter illegally should be able to have children who are citizens. And that's where this discussion we were having about punitiveness versus deterrence versus costs and benefits comes in. And that's where I think we should be having the conversation. If people want to unsettle birthright citizenship, don't do it by issuing an executive order that contravenes statutes and the Constitution. Do it by introducing a constitutional amendment. See what people actually think about the matter, as opposed to trying to do it by fiat and through getting the Supreme Court to agree to your side.
Well, the Justice Department's position is that this doesn't need a constitutional amendment, that we have a misinterpretation of the constitutional amendment, and the same argument would apply to desegregation of schools. Well, Plessy has been decided, so we have to amend the Constitution. No, actually, we just need to address the issue at the court. And, I think there's probably a 50-50 chance at best that the side I'm taking here wins. I mean, I would be kind of surprised if it does, honestly. I think it's correct, but I don't think that it necessarily gets anywhere. But that's where we decide the constitutional question. And so Donald Trump is raising the issue. It will go to the court. We will have some kind of determination about which one of us is right about the 14th Amendment. We will still disagree, and it may come up in 100 more years. But the point is, I don't think he's doing anything by executive order that's illegitimate. I think what he's doing is he is provoking the case in controversy necessary to decide this.
If I could just make a prediction, I think the most likely outcome at the court is that the court will say that this executive order is inconsistent with congressional statute and not even decide the constitutional question. Those statutes have been in place against a backdrop of interpreting the Constitution broadly in the fashion that I've been defining it. And that's clearly what those statutes mean. And I think it's the easy way out for the court without having to engage in these constitutional questions. So I think that's what's likely to happen. And then we'll see if the momentum behind amending the Constitution goes anywhere, or if Congress then tries to come back and change those laws. And then we would have a debate about whether Congress can change its laws and reinterpret the Constitution. That's different from the president doing. So I think there were more people who would agree that Congress has that authority through its power to enforce Section 1 of the 14th Amendment. I would happen to disagree with that, but there I think we're on a different terrain than we are when we're talking about the president deciding to contravene existing statutes and himself, through an executive order, redefine longstanding constitutional understanding.
Well, I don't think that's what he's doing, but I agree in principle. It would be better if Congress were to attack this issue with some vigor. And if you want to have a more generous immigration policy, you can probably get me to sign up for that. But what we have to do is we actually have to insist that people come legally. And one of the things that we must distinguish is that you're not entitled to the benefits of citizenship of the United States just because you show up. Nobody who's already a citizen is getting their citizenship revoked. That's just not going to happen, and it shouldn't. It's horribly wrong. But if you are currently coming to this country unlawfully and you violate the law, then you don't fall in the same status as the people who came legally. That's all. And I want them to come. I just want them to come legally.
And Rod, I'm just going to jump in there, and thank you for clarifying this point around retroactive versus what happens moving forward. I appreciate it. I know we're almost at time, and we just need to do one final wrap up because we end every episode of The Disagreement in the same way, which is with something called steel manning. Cristina, Rod, are you familiar with that concept?
No.
All right, let me lay it out really quickly. So when you steel man, the objective is to build kind of the strongest, most compelling version of the argument that's the opposite to the one that you've made. So you're really articulating your disagreement partner's point of view. And we do this as a way to show respect that we've heard the other person, that we've taken in their views. So I'm going to ask each of you to quickly steelman the other's position here on birthright citizenship.
Oh, cool.
Do we have a volunteer of who wants to go first?
I'll go first.
Thanks.
I will say that the position is that the country's been misinterpreting the citizenship clause, that if you go back to its original meaning, subject to the jurisdiction thereof, it excludes people who are born to parents who have an allegiance elsewhere. We can assimilate unauthorized immigrants into that category. And even the precedent of Wong Kim Ark is applicable to someone who had a permanent domicile in the United States. But even if there's question about the constitutional argument, as a matter of policy and citizenship theory, we should go the direction of most of the rest of the democratic world, which is to limit those who can give birth to citizens inside the U.S. territory to people who have some claim of permanence to residents in the United States, and that is the children of lawful permanent residents and U.S. citizens.
Nice, Cristina. I think I'd give that an A. I'm not sure, Rod, how you would grade that steelman. I thought it was pretty great.
I hope I can do as well.
All right, Rod, you're up.
The professor's position is simple, and I think fundamentally compassionate and strong, even where I disagree with it, that the 14th Amendment was not narrowly intended to cover the children of slaves, that there was a fundamental debate in Congress about the nature of people who come to this country from whatever source, and that slaughterhouse doesn't really apply. We didn't ever talk about Elk v. Wilkins, so I don't actually know the professor's position on that, but that Wong Kim Ark establishes right to citizenship on the behalf of the children of immigrants, regardless of their status, and that our case law and not so much our case law as our legislation since that time has been consistent with that position. But more importantly, that it's fundamentally compassionate, that it's fundamentally fair, and that we should not punish children for the sins of their parents. And I completely agree with that.
Cristina, what score would you give Rod Steelman?
I'd also give it an A.
Oh, love that. All right. Rod, Cristina, thank you so much for taking the time to be here with us today. I know we covered a lot of different topics, jumped around a bit, but really appreciate your willingness to engage in a kind of good faith dialogue here around birthright citizenship. So thank you so much.
I'm tickled to meet both of you. You are both amazing.
Very nice to meet you both, and I'm glad to have been in this conversation. It's really important.
Yes.